Civil Liberties Research Center for sponsoring this event. It's sort of a new thing that we have sponsored lectures, and being the recipient of this honor is rather nice, so thank you very much for this. Now, my topic today is, as stated on the slide, democracy and freedom of expression. I've added threats and challenges in the internet age. And I'm going to talk on several topics, and I hope to be done with a question period by no later than 1:30. So let me begin. When words were first printed rather than spoken, a monumental shift in the way the human species communicated with each other occurred. The content of the written word could be distributed again and again over long periods of time to an indefinite number of readers. No longer limited to a listening audience, the creative explosion that resulted from the written word fueled masses of intellectual development and the emergence of new societies from the hunter-gatherer societies. Now, I mention that because with recent advances in technology, specifically the development of the internet, we find ourselves on the verge of a similar shift. Today, people can not only distribute messages to numerous recipients almost instantaneously around the world. Unlike the limitations of the printed word, there is now the ability to respond and share views and opinions to this vast audience. At the cutting edge of this technology, we find social networks such as Facebook, Twitter, Instagram, MySpace, Bebo, and numerous others. Some find these new methods of communicating exhilarating. They see the internet as one of history's greatest engines of democracy and the restoration of community, a kind of national town hall in which everyone gets to speak, thereby strengthening democracy. This kind of cyber democracy was seen as a potential cure to several of the problems that have afflicted most representative democracies in the late 20th century. Problems such as voter apathy, the narrowing range of political debate, the media's propensity to reduce discussion of complex issues to sound bites, and the increasing influence of private corporations and other sources of wealth on public policy. All of these conditions might be ameliorated, it was suggested, by the ease with which ordinary citizens could obtain information and then cheaply make their views known to one another through the internet. Debate on public issues would be more uninhibited, robust, and wide open. Smaller entities and even individuals would be empowered to widely disseminate their messages and indeed reach audiences as broad as those reached by established media organizations. Recently, however, this rosy view has come under attack. The internet, skeptics claim, is not a giant town hall. The kinds of information flows and discussions it seems to foster are in some ways disturbing. Andrew Shapiro, who's the author of a book called The Control Revolution, said that the early euphoria over cyberspace has been replaced by a kind of techno-realism, a realism critique that is less convinced of the internet's value. One source of trouble identified by law professor Cass Sunstein, who's at the University of Chicago, is that the internet encourages like-minded persons, often geographically dispersed, to cluster together in bulletin boards and other virtual clubs. When this occurs, the participants tend to reinforce one another's views without considering others. The resultant group polarization can be ugly. Society can fragment and communities dissolve. He says such environments reinforce pre-existing viewpoints and undermine the constructive dialogue that promotes progress in democracies. He worries that the internet has created a world of seemingly infinite choice where citizens are transformed into consumers and a shared political culture is eroded. Another law professor, Lawrence Lessig at Stanford University, argues that the enormous amount of personal information people reveal when they shop online, browse websites, or call up information offers extraordinary opportunities for both governments and businesses to control people's lives. Left to itself, he writes, cyberspace will become a perfect tool of control. Still, others find the amount and kind of expression dominating the internet to be offensive, shallow, invasive, and degrading. Pornography, hate speech, lurid gossip, bullying, cyberstalking, and explicit violence, forms of expression that flourish on the internet, while debates that would strengthen democratic ideals tend to get lost in the noise. What I'd like to do in this presentation is to examine some of the issues on both sides of this debate, issues that have arisen because of a lack of controls and filtering, and issues that have arisen or could arise from too much interference, and how both relate to democracy and the pursuit of freedom expression ideals. So that brings me to my first slide. The topics I will specifically discuss are freedom of expression and privacy, freedom of expression and government surveillance, freedom of expression and international treaty making, and freedom of expression and hate speech. All four of these topics inevitably implicate our supreme law, the Canadian Charter of Rights and Freedoms. Section 2B of the Charter says everyone has the following fundamental freedoms: freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. Now, this right includes the right to express, but it also includes the right to not express. And that's an important reality in terms of the internet. Section 1 of the Charter makes it clear that freedom of expression is not an absolute freedom. Because as you can see here, Section 1 says, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Now, people's privacy interests in expression are protected from government authorities through judicial oversight mechanisms, such as, most commonly known ones, are search warrants. These protections are grounded in Section 8 of the Charter, which says, everyone has the right to be secure against unreasonable search or seizure. Now, finally, people's equality rights must be taken into account when considering whether free speech protections are given to hate speech or forms of pornography. Now, Section 15 protects equality rights from that type of assaultive speech, saying every individual is equal before and under the law and has the right to the equal benefit and equal protection of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Now, the Supreme Court of Canada has described the purpose of why we protect freedom of expression in a free and democratic society. And this is very important as well. Because the purpose of protecting freedom of expression is not only to support democracy as a huge pillar supporting it, but it also assures individual self-fulfillment. It is a means of obtaining the truth. It is a method of securing participation by members of society in decision-making, and it is a means of maintaining the balance between stability and change in society. So you can see that freedom of expression rights support democracy through certainly politicians and groups and organizations in society, but the freedom of expression right is as important to democracy for individuals. So now turning to privacy and access. Privacy issues arising out of the internet use include third-party personal information disclosure, cyberstalking, and government surveillance. And I'm going to talk about all those three under this heading. Third-party information disclosure is a violation of privacy rights when information posted online provides identifying information about persons other than the user. For example, the decision to upload a picture to Facebook lies solely with the user uploading the photo, even though others who may be in the photo are exposed, disregarding their right to privacy and their right under Section 2 of the Charter not to express themselves. Third-party information disclosure occurs in other ways as well. Most users are not aware that their personal information is made available to the public, to the general public, unless they modify their privacy settings. Consequently, users often put up information solely intended for family and friends that ends up being available to the public at large. In December 2009, Facebook drastically and unapologetically changed its privacy policies, allowing users even greater access to the privacy of others. Lists of others' friends were made available, even if the users had previously indicated they wanted to keep these lists private. Also, photos were made publicly available by default, often without the user's knowledge. Facebook lacks any form of filter and leaves the decision to upload entirely up to the user. Facebook also does not place any restrictions of freedom or equality on the content posted by its users. The only exception is that Facebook will remove any content that is found to infringe or violate someone's right or violates any law. This is rarely done, and when it has been done, it's usually been when a state bans certain information. As Malik would know, this happened in Turkey just a few months ago when the state banned Twitter, and Twitter respected that ban because it was against the law of Turkey at that point in time to use Twitter. So that's when Facebook and Twitter sit up and pay attention. That may surprise you, but that's what happens. And with an audience of 800 million registered users, enforcement of its own rules is sporadic and is driven by complaints of users rather than oversight by Facebook itself. Additionally, Facebook's mission, and this is important, is to encourage users to provide detailed personal information, so it is not surprising that they are slow to take action against any third-party information disclosure. It certainly lacks an incentive to do so, as Facebook today makes billions of dollars by selling private subscriber information to advertisers. Now, the next topic I wanted to address was cyberstalking. Internet privacy concerns overlap with personal security when the location of a user can be mapped without their knowledge, leading to problems identified now as cyberstalking. An application actually named Creepy can track a person's location on a map using photos uploaded to Twitter or Flickr. When a person uploads photos, others are able to track where they are. Smartphones able to embed longitude and latitude coordinates into the photo can automatically send this information to the app. This poses many potential threats to users' security when they share their information with a large group of followers, as anybody using the app can search for a specific person and find their immediate location. Another privacy issue with social networks is the agreement that users enter into when signing up for a social media site. Facebook's privacy agreement states that the social network owns all of the content that users upload. This includes pictures, videos, and messages. All are stored in the social network's database, even if the user decides to terminate his or her account. And that information can be used by Facebook for commercial or other purposes. Now, government surveillance. The use of social network websites in police investigations is becoming increasingly common. The RCMP and CSIS have dedicated undercover agents on Facebook, Twitter, MySpace, and LinkedIn. Their rules and guidelines with respect to privacy are not released to the public. Agents can impersonate a friend, a long-lost relative, even a spouse or a child. Although people who use Facebook, Twitter, and other social networking sites are aware that some level of privacy will also always be compromised, it is likely they wouldn't suspect a friend request might be from a federal agent whose sole purpose is online spying. This surveillance capability exponentially increased on October 10th, just a few days ago, when the Harper government passed Bill C-13, the Protecting Canadians from Online Crime Act, often referred to as the Anti-Cyberbullying Bill. This act makes it a crime to transmit pictures without consent, and it removes barriers to getting unwanted pictures removed from the internet, all of which is good for the protection of privacy and the prevention of cyberbullying. However, the bill goes much farther beyond this purpose, threatening privacy rights of all Canadians by granting legal immunity to internet service providers when they provide subscriber information to the police without a warrant. Even though the Supreme Court of Canada just last June, in the Spencer case, which was a child pornography case, unanimously declared that a warrant is required to get subscriber data, the government went ahead with this bill that many experts now think will again be found unconstitutional because it completely bypasses all the mechanisms for obtaining warrants. The Spencer ruling also addressed the broader constitutional issues raised by Section 8 of the Canadian Charter of Rights and Freedoms, which protects Canadians' privacy rights from unlawful search and seizure. It said, the court is speaking here, the disclosure of this information will often amount to the identification of a user with intimate or sensitive activities being carried out online, usually on the understanding that these activities would be anonymous. Those are now available under this new legislation to any law enforcement party without a search warrant. Judicial oversight will not exist under the new law. In effect, the bill creates a system where someone in a government office can pick up the phone, call an internet service provider, make an urgent request, and the service provider will send the subscriber's information. Authorities will be allowed to create detailed profiles of Canadians based on who they talk to and what they say and do online, regardless of whether it is in connection to the investigation of a crime. This is in the context of already recorded abuses. The Acting Information and Privacy Commissioner announced that in 2012-2013, government agencies made at least 1.2 million requests for information from internet providers. Are there 1.2 million terrorists in Canada? Or 1.2 million criminals that we need to obtain information about? It is noteworthy the internet service providers were the ones who blew the whistle and provided this information, not the government. There was no explanation coming from government when asked as to why these requests were made. Another threat to democracy on a broader scale came to light with revelations by Edward Snowden. He released top-secret documents that indicated Canadian spy agency CSEC, which stands for Communications Security Establishment Canada, authorized its American counterpart to conduct extensive spying operations on Canadian soil during the 2010 Toronto G20 summit that CSEC itself was not authorized to do. So CSEC giving authorization to an American spy agency when they themselves could not operate that kind of surveillance. The Snowden documents reveal that the spying at the Toronto summit in 2010 fits a pattern of economic and political espionage by the powerful US intelligence agency and its partners, such as Canada, the UK, Australia, and New Zealand. One of the most egregious revelations was the invasive industrial espionage spying that the Canadian government was caught doing against Brazil's mining and energy ministry. Subsequently revealed that CSEC had been holding top secret meetings with the Canadian energy companies twice a year since 2005. Now, OpenMedia.ca, an NGO working to protect the internet freedoms, joined with the BC Civil Liberties Association in a lawsuit alleging that CSEC spying is illegal and unconstitutional. The legal action challenges the constitutionality of federal legislation underpinning the establishment of CSEC. And the British Columbia Civil Liberties Organization is also challenging the constitutionality of the government's warrantless collection of data, including data on Canadians' everyday internet use. Now, the final point under this heading of privacy is international treaty making. A further threat to freedom of expression on the internet is looming with the proposed Trans-Pacific Partnership Free Trade Agreement. Leaders from 12 countries, including Canada, and the discussions are ongoing as we speak, are about to lock into place binding internet censorship rules through an international agreement called the Trans-Pacific Partnership, TPP. The TPP is a secretive, multinational trade agreement that threatens to extend restrictive intellectual property laws across the globe and rewrite international rules on its enforcement. Under the TPP proposal, and some of this information has come from WikiLeaks because this whole process has been secret, internet service providers could be required to police user activity, take down internet content, and cut people off from internet access for common user-generated content. Experts say violations could be as simple as the creation of a YouTube video with clips from other videos, even if for personal or educational purposes. Mandatory fines would be imposed for individuals' non-commercial copies of copyrighted material. So downloading some music, for example, could be treated the same as large-scale for-profit copyright violations. The TPP proposes to impose copyright protections for a minimum of 120 years for corporate-created content. In sum, the TPP raises significant concerns about citizens' freedom of expression, due process, innovation, the future of the internet's global infrastructure, and the right of sovereign nations to develop policies and laws that best meet their domestic priorities. It puts at risk some of the most fundamental rights that enable access to knowledge for the world's citizens. All right, so now I'm going to turn to the last topic, which is freedom of expression and hate speech. The medium of choice of most hate groups today is the internet. Because of its reach, the internet allows members of hate groups from all over the world to engage in real-time conversations with each other, encouraging intolerance, violence, discrimination against groups they despise. The internet has been a windfall for the spread of their messages and the recruitment of new members. Today, according to the FBI, CSIS, and other law enforcement agencies and human rights groups, some of the most active hate groups are those targeting younger audiences, who in turn form their own hate groups through social media. Using Facebook, for example, hate page group creators choose their target, set up a site, and then recruit members. Anyone can create a Facebook group and invite followers to post comments, add pictures, and participate in discussion boards that can amount and have amounted in lots of cases to a form of online hate speech. This is exactly the reality that teenagers Rita Parsons and Amanda Todd faced, culminating in their suicides from cyberbullying. The use of Twitter by trolls is an emerging form of hate speech, as are sexually explicit displays and often depictions of luridly violent abuse. Twitter sites rules explicitly ban threats of violence, but users, in order to do something about this, have to fill out a very unwieldy online form to report abuse. The debate now is whether Twitter is doing as much as it can or whether they should do more. Some say Twitter can't and shouldn't police the internet. They argue that most online talk is just that, talk, never intended to translate into action. Others argue that proposed solutions, such as report abuse buttons, could themselves be abused by governments to silence their opponents, or by celebrities to muzzle their critics. The Simon Wiesenthal Center, in its 2009 I report, identified more than 10,000 problematic hate and terrorist websites and other internet postings that participate in online bullying, recruitment and radicalization of youth into hate and terrorist organizations, and other situations of hate organizing. The report includes hate websites, social networks, blogs, news groups, YouTube, and other video sites. In Canada, a 2011 Senate report on security, freedom, and the complex terrorist threat found that young people are finding radicalizing material too easily online, including video and audio recordings that could generate emotional urges to react violently to perceived injustices. They recommended the government seek new ways of limiting access to radicalizing material on the internet and work with community leaders to respond to messages that glorify violence. Now, there's no question that hate speech is effective. In 2009, Canadian Police Services reported 1,473 hate crimes, an increase of 42% from previous years. Almost 30% of hate crimes incident in 2009 were motivated by the religion of the victim, over 20% of which involved actual violence. Hate crimes motivated by homophobia were much more likely to involve violence directed towards the victim. In 2009, 74% of incidents against homosexuals involved violence, compared to 39% of racially motivated incidents. None of these statistics includes the effects of the increasing proliferation of hate discrimination against children through child pornography and the violent, degrading pornography promoting hate discrimination against women. Although the federal government repealed the Section 13 of the Canadian Human Rights Act that dealt with internet hate speech, the Supreme Court of Canada recently decided that a hate speech case which validated provincial human rights laws which prohibited it was certainly constitutional. This was the Whatcott case. I argued in that case. The case involved respondents passing out pamphlets denouncing homosexuals as pedophiles and carriers of disease and people who should be killed. The Saskatchewan Human Rights Code forbids any publication or display that tends to expose to hatred any person or class of persons. I'll just put that up. This case took place, of course, in Saskatchewan, so Mr. Whatcott, who was distributing these hate pamphlets, challenged this law and said that it was unconstitutional because it violated his freedom of speech. get to a further discussion of that in a moment, but I also would point out that in Canada, in addition to human rights laws about hate speech, we also have criminal code provisions that forbid hate speech. And these laws were constitutionally validated in the Keekstra case, which was also a case I participated in. The criminal law reads as follows. Section 319 of the Criminal Code prescribes penalties from a fine to imprisonment for a term not exceeding 2 years for anyone who incites hatred against any identifiable group distinguished by color, race, religion, ethnic origin, or sexual orientation. There are numerous defenses to hate speech laws at the criminal level. If the speech communicated was true, if it was made in good faith, attempting to establish an opinion on a religious subject, if the statements were relevant to the public interest, which a discussion of which is for the public benefit, or if it was made in good faith intending to point out for the purpose of removal matters producing feelings of hatred towards an identifiable group, meaning if a group used as an example the kind of hate speech to say this should be against the law, they cannot then be accused of hate speech, that sort of thing. So there's significant defenses for criminal prosecution of hate speech, which makes success in these prosecutions very difficult. And also to take a prosecution under the criminal code, the Attorney General's permission is required, which often becomes a political issue, and that permission is often not granted. Section 320 allows a judge to confiscate publications which appear to be hate propaganda, so there is a confiscation provision. Now, hate speech laws, when they are challenged, are balanced against freedom of expression in terms of the harms that the speech causes. The damage the court found in the Whatcott case, the pamphlets that attacked homosexuals in Saskatchewan, was considered damage to both our democratic imperative of equal citizenship and damage to the complainants personally. The court found that Whatcott's pamphlets were hate speech because they contained a permanent denunciation of the equality rights of homosexual citizens in terms that a reasonable person would say provoked hatred against them. The hate speech further damaged the dignity of all homosexual citizens, their social standing, and their right to be treated equally as they go about their daily lives without facing violence, hostility, hatred, and discrimination by others, the court said. The court found little value balancing that against freedom of expression because in terms of truth-seeking, encouraging participation in political decision-making, and cultivating self-fulfillment and human flourishing, the pamphlets fell quite short, especially in the balance of those harms I just mentioned. As such, Whatcott's expressive rights were not violated to the extent that they would outweigh the equality rights at stake for those that were targeted by the expression. And the court upheld the law. The importance of the Whatcott decision to the battle against hate groups, terrorist networks, the radicalization of children and youth, and the use of internet for bullying cannot be understated. Showing footage of the decapitation of people on the internet, recruiting converts to carry out violent hate crimes, and silencing criticism by threatening human rights defenders with violence and harassment have all been used as internet tools for the furtherance of hate. If challenged, none of these forms of expression would pass muster as legitimate expression under the Charter, according to the Whatcott case. So, threats exist on the internet to democracy through its fragmentation of community, through invasions of privacy and the right not to express, through secretive surveillance, government interventions, and treaty making to limit access, through hate speech, bullying, and threats. What can we conclude? I think the conclusion is clear. Society must begin to make more conscious choices about what it wants the internet to be. Internet providers can write software to allow users maximum privacy, or to track and restrict their movements to an extraordinary degree of control. The software engineers, as Percy Bysshe Shelley said of poets, are the unacknowledged legislators of our time. We must acknowledge this reality and try to shape it. Some organizations are working very hard to do this shaping. And I put up one. I happen to be familiar with this organization. People often ask after a presentation like this, well, what can I do? Well, openmedia.ca is an organization which is doing its very best. It's a non-profit, non-partisan organization. It's international, but the Canadian headquarters are in Vancouver. And they work to encourage open and innovative communication systems within Canada. Openmedia.ca's stated mission is to advance and support a media communication system in Canada that adheres to the principles of access, choice, diversity, innovation, and openness. Open Media was the primary organizer behind the SaveOurNet.ca coalition, whose aim it is to protect openness, choice, and access for Canadians in Canada's internet. Among other activities, openmedia.ca spearheaded the StopTheMeter.ca campaign against usage-based billing in Canada, including an online petition that acquired over 400,000 signatures and caused the CRTC to re-examine its decision on the way Canadians are billed for internet usage. So this concludes my remarks, and I would encourage you to either get involved with openmedia.ca or many other affiliated organizations which you can see on their website who are trying to address all of these problems that I've identified today. So thank you for your attention.